The first matter to come before us this morning is State of Ohio versus Donzelle Crosby. Both sides will have 15 minutes to argue this morning. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve any time for rebuttal, if you let me know when you get started, I'm keeping the clock and I can keep you apprised of the passage of time. We've read the briefs and we're ready to see when you are.
Thank you, Your Honor. And may it please the court, I am John Coe. I am the Mr. Crosby's attorney that was appointed on appeal. And first I would like to reserve 5 minutes in rebuttal. Mr. Crosby had a long time to the criminal justice system in his aggravated murder case. It was a capital case that lasted a little over 3 years, that went through a full Atkins hearing, competency hearing. Mr. Crosby was found to have an IQ of 52, where the capital specifications were withdrawn. It proceeded to a trial. Mr. Crosby was found guilty of aggravated murder. At this juncture, Mr. Crosby has filed 4 assignments of error. Ineffective assistance of trial counsel, that the convictions were against the manifest weight of the evidence, that the convictions, that the state did not have sufficient evidence for the convictions, then also that there was an abuse of discretion with the competency hearing and then the Atkins finding afterwards, or whether that put the court on notice to revisit the competency issues.
Why would the court have to revisit it?
When Mr. Crosby was found in March to be competent, about a month and a half later, there were additional reports that were filed where the state and Mr. Crosby came to a stipulated IQ of 52.
And thus he wasn't eligible for the death penalty.
Correct. And the original competency hearing was centered around a lot of malingering, and that leading to, if he was intelligent enough to malinger, then he was intelligent enough to be found competent at the stand of trial. Now, what ended up happening is when this stipulated IQ of 52, there wasn't that low of a bar found at the original competency hearing. There was no explicit finding of the intelligence of Mr. Crosby, and we later had this stipulation that low. And it's Mr. Crosby's belief that counsel made the argument, obvious, Mr. Crosby couldn't. Counsel makes the argument that that additional Atkins report that was filed in the trial court should put the court on notice that, hey, you know what, let's revisit the competency now that we have a report that shows Mr. Crosby's intelligence this low.
But there's no appeal from the competency evaluation finding the first time through, right?
No, but when you read the record, what happened is the competency hearing happens and the Atkins hearing happens, and rightfully so, trial counsel, their first concern was the death penalty, and they got the death penalty off the books, and then they were going ready for trial just a couple months later. At this point of the competency hearing, I think Mr. Crosby was on his 6th or 7th attorneys, and I think just from looking at the record that they were started gearing up to prepare for the murder trial. It was not appealed after.
Well, and then when it's the case that Mr. Crosby's IQ wasn't learned until later, either through a succession of counsel or otherwise, there was no, just before the commencement of trial or any time, there was no, I guess never a motion that his competency finding be revisited at any point.
And that is absolutely correct, Your Honor.
So it would have to be plain error, since there's nothing below. I mean, I think the brief argues that it's abuse of discretion.
Well, plain error is pretty hard appellate standard to me. What I used, I think it was Johnson, that used the abuse of discretion because it would have been in the knowledge of the trial court, all of this information. So they were hearing the competency, they came to the advocate's determination, and at that time, everybody was in the knowledge of the facts, and that's when the next step should have been taken. It would have been unreasonable not to refer it back for another competency after those intelligence questions came back.
Still not understanding what would be gained by the second competency hearing, which would not also have been demonstrated by the first.
The competency hearing did not take into account Mr. Crosby's actual IQ that was stipulated by the parties. The original competency hearing was focused on whether he knew. It didn't take into account what his actual current IQ was when the competency interviews and all the facts leading to the competency interviews did not have that knowledge that there was a stipulated IQ of 52.
So are you saying that an IQ of 52 automatically means you're not competent?
No, I'm just saying that they should have been able to take those reports in. I mean,
So somebody with an IQ of 52 could very well be competent.
could be very well competent, but I think it should put red flags for everything. That, you know what, we need to go back, we need to revisit this issue. I mean, we just had a hearing that, I think it was a day or two long, where the state and defense focused on competency, and during that, they never talked about what was Mr. Crosby's IQ recently. And that should have been something that everybody in the court should have, okay, let's step back, let's take this information, let's refer it back to the competency people. If they say it wouldn't have had an effect, then at least we have an opinion of that. But we have nothing. And that IQ should have been transferred and used in a competency argument, because 52 IQ is substantially lower than a 70 IQ that you find on our athletes. And then the other three assignments of error were manifest weight, sufficiency. In the brief I cited the economic factors. At the court there were two eyewitnesses that were able to identify Mr. Crosby as the shooter. That was Jeremy Brown and Michelle Neal. And they had wildly different testimony. And when you apply the economic factors of contradiction in testimony, impeachment, what was not proved, the trial court accepting the incredible as true, certainty, reliability, self-serving statements, and vague statements. Michelle Neal was a manager of a crack house in Lorain. The day of the murder was after a lot of crack users had their government checks. She had people come into her house. She had people selling out of her house. She gave an identification testimony about Mr. Crosby shooting and killing the victim in this case. There was another second ID witness, and that ID witness was Jeremy Brown. He was a co-defendant. He put the gun in Mr. Crosby's hand and said he was the shooter. But when you take their testimony together, it is wildly different. Neither of them give testimony that the other one was there. So Michelle Neal never says that Jeremy Brown was there. Jeremy Brown never says that Michelle was in the room. One of the witnesses, Michelle Neal, says that the group of boys that committed the robbery and murder, they were at the house twice. Jeremy Brown says they only went once. Jeremy Brown, at the time of the shooting, he testifies that Donzelle wasn't even in the bedroom where the murder occurred. He shot from outside the bedroom.
And Counsel, you're just now reaching into that 5 minutes. You can continue or reserve as you wish.
I'll continue. And when we take this evidence as a whole, Your Honor, you apply the accommodative factors, and they did that in the brief. It's all of the inferences that go with this testimony. So we have two wildly different stories. And normally manifest weight cannot just be on the testimony, and counsel knows that, but it's also you look at the inferences of all that testimony. There was later on testimony by an expert witness that gunshot residue was found on some of the other parties, in this case's hands. And it just does not make sense when it comes to the manifest weight standard. And then the sufficiency argument requires some credible evidence for every element of the offense. And the same thing with these contradictions. The state does not believe that sufficiency of the evidence could be made. The ineffective assistance of counsel, counsel cited State v. Pruitt, which was a recent 8th District Court of Appeals case where officers that basically did an intake of statements from a victim of a crime, then testified at trial, and the state didn't work. Defense did not object to the witness, to the police officer's testimony that, hey, we took these records in, and basically the 8th District gave it as a whole string of testimony and allowed it to be the reversal for ineffective assistance of counsel.
But Pruitt was just a situation where there was no direct testimony. It was all inferences that were coming in through an editorialized version.
I was trial counsel in Pruitt, and there was an accounting. There was witnesses. The victim of the case actually came in and testified to that. And it was the fact that when the officer gave that testimony about taking all those things in, it allowed almost a corroboration. I believe that was the district's main issue with the failure to object in that. And then when we take to this case, we have 3 or 4 witnesses that I cited in my brief. I believe this would rise to the level of a deficient performance that was prejudicial under Strickland grammar. Do you have any time left?
About 2 minutes.
Can I reserve that for the end? Thank you.
Good morning, Your Honors. May it please the Court, Mary Solanski on behalf of Pelley of the State of Ohio. I would like to start with the competency issue because I think, Judge Hensel, you touched upon something that I wanted to also speak about. That was that there was no objection to the actual finding. There's no assignment of error to the actual finding of competence. What we have is that the trial court should have sua sponte, which I know they can and should do, have raised this issue again. What you said that I wanted to touch upon was that this notion of abuse of discretion, and the reason that comes into play is if we were looking at the trial court's decision on competence, the standard is abuse of discretion. But Judge, I agree with you, they didn't assign that as error. They didn't assign as plain error the failure of trial counsel to object. And so I don't think that this court can consider it under plain error. So I just want to make that clear that I don't believe that that's why the state didn't argue it, because it wasn't raised in that manner. What the defendant did argue was that there was some evidence that came in, direct evidence of a stipulated IQ of 52 at the Adkins hearing, which was about a month and a half or so after the competency finding by the trial court. What I want to point out is that when you look at the testimony of the defendant's expert at the competency hearing, he's acknowledging, well, the report for the Adkins hearing with the IQ isn't done, but the IQ is in the low 50s, and that, I believe, was directly what he said, that it's in the low 50s. Moreover, defense counsel actually, in speaking prior to putting that witness on at the competency hearing, said, well, Your Honor, my client has an IQ of about 55, and I think that when you look at all of that, the court was aware this is a gentleman who suffers from mental retardation. There was never any dispute, any real dispute. And look at the fact that the state stipulated in that report as far as that death penalty specification. We knew we were done with this gentleman. It wasn't a close call. So the notion that now, because we knew his IQ was around 55 at the time of the hearing, that because later we find out that it's 3 points lower at 52, I can't see what difference that would have made. And the abuse of discretion comes in because we talk about what did the court consider and would it have made a difference when we look at this ineffective assistance of counsel standard for not raising it, that they also bring up in their brief.
Well, with respect to the finding of competency.
Yes.
I get the flavor of the argument to be that part of the decision that he was competent to stand trial was that he was somehow malingering.
Correct.
And I think that part of the argument is that there may be something to a person's IQ level and their ability to malinger, which wasn't fully explored at the time. Is that kind of where we're sitting at when we get to the Adkins hearing?
I think that may be where counsel is going, but my point is the court may not have made an explicit finding that this evidence, there was this evidence of the malingering, but there's also nothing in the record to suggest, and I'm not aware of any case law that says a person that has a low IQ can't also malinger.
There was no testimony with respect to that.
There was no testimony with respect to that regarding the IQ and the malingering. I don't believe that was directly explored. But the court was aware of the IQ. Not only that, the expert who testified on behalf of the defendant at the competency hearing was aware of what that IQ was, and he was still addressing and talking about the malingering and the state's expert and all of that. So to say that the court kind of considered this malingering in a vacuum really isn't accurate, because the court also had this evidence that this person has an IQ that's very low. And the state really didn't even dispute the IQ issue at the time. The notion about abuse of discretion is that did the trial court abuse its discretion when it made that decision? And I think the only significance that has here is, because it wasn't assigned as error in the first instance, is that having known that the IQ was 52 as opposed to low 50s or 55, would still not have made the trial court's decision an abuse of discretion, which means that it was an error for trial counsel to say, hey, I need another competency hearing because now we have a stipulated IQ of 52, and it wasn't improper or an abuse of discretion for the trial court, although I don't think abuse of discretion is the standard, it would be plain error. It wasn't improper for the trial court to say, hey, I'm going to have another competency hearing. So that's where that kind of abuse of discretion comes in when you look at it as what did the court know when it made the decision and abuse of discretion was the correct standard versus these arguments now that we have that this stipulated IQ of 52 should have raised a bunch of red flags and caused everybody to kind of step back, and defense counsel that request a hearing in the court to sua sponte conduct one or somehow decide that it needed to revisit that issue. I don't think is accurate in light of the record, because I don't think that when your IQ is already that far below the Adkins standard, which is 70, I don't think it makes a huge difference. And the trial court rightly focused on, does this defendant understand the proceedings? Does he understand what he's charged with? and what could happen to him, and can he assist his counsel? And the court got it right, and the state submits that even in hindsight, knowing that his IQ was a stipulated IQ of 52, the court got it right. That's what, the court applied the right standard in that those few points in IQ, when you're already in the 50s, would not have made that substantial of a difference if the court would have said, I need to relook at this. You know, it wasn't as if the court had assumed that his IQ was borderline 70 and then found out that it was nearly 20 points lower than that a short time later at the actual Atkins hearing when they stipulated that IQ of 52. So it wasn't a question of a big disparity. We're talking a couple of points difference between what the court found out later was the actual IQ and what everyone was testifying they believed his IQ to be in the neighborhood of. So it was only a few points. So I think, unless there are any questions, I'll move on. I wanted to touch upon some other things that counsel had pointed out. I think that it's kind of a mischaracterization to say that the witnesses in this case gave wildly differing accounts. I think that the testimony speaks for itself in this case. There were not just two identification witnesses, there were actually three. You had Michelle Neal, whose home it was, and I've never heard the phrase that someone was a manager of a crack house, but I suppose it fits in this instance, and she didn't deny that. She said, I freely allowed people to use my house to come in to sell drugs. I allowed the victim to do that. I had previously allowed the defendant to do that. Everybody knew it was a party house. You could come here and get what you want. And, you know, and that, I think, speaks to her credibility, and I think that resounds with the jury. You know, that strikes with them, because this is somebody who isn't trying to avoid criminal liability, and I think there was even a suggestion in defendant's brief that, you know, they lumped her in with Mr. Brown as a co-defendant because she wasn't charged with permitting drug abuse. Well, she wasn't giving self-serving testimony to try to avoid blame, as someone might argue that Mr. Brown might have done, although I don't think that that's an accurate assessment either. But to lump her in with a testifying co-defendant and say she's giving a self-serving statement here is really a mischaracterization, because she clearly owned up to, I ran a crack house, I was the manager of a crack house. And so I think that frequently sounds well with the jury when you have someone that can come in, admit their past mistakes, and go on. And I think the other thing that just moving away from the manifest weight, that touches on that ineffective assistance of counsel and the failure to object, because the testimony by Detective Seibert was not bolstering her credibility when he was talking about how she looked at trial as opposed to how she would have been back at the time of the murder, because he testified he was absolutely shocked at how much better she looked. And I think that the reason that you don't have an objection to that testimony, although I don't know what the basis would be, but the reason there's no objection at that time is because defense counsel, certainly that's going to play into, at the time of this murder, she was a hot mess, and what she says she saw back then wasn't reliable, regardless of how she looks today, how nice she looks today. So I think that it helped the defendant's case to say she was not credible, because as the state, I'm sure the court's aware, we always get accused of cleaning our victims and witnesses up and making them look so presentable when they come in. And in this case, that certainly came into play, because defense counsel was then able to argue back then she was a crack addict. She had all of these issues, and so you shouldn't believe her testimony today about what she's saying she remembers from back then when, oh yeah, can I stress enough, she was a crack addict? You know, I mean, I don't see an ineffective assistance in that basis, and I think that it supports her credibility with the jury, especially on manifest weight. And as far as Detective Seibert bolstering her testimony, I don't believe that that was bolstering. And I just want to speak briefly to Pruitt, because in that case, when we're talking about bolstering, what you had was and what was referred to as an intake detective, who basically said, a victim came in and said, I've got an employee that's stealing from me. Here's what, you know, this is what I'm telling you. And the detective is then kind of testifying at trial that he doesn't have any, I think the quote from the 8th District was, he didn't have any reason to disbelieve this witness. And that's what the 8th District felt was the bolstering of the testifying, complaining witnesses. I don't think that was a case where the 8th District was saying the officer was making all of these statements at trial and that was the only evidence. The victim came in and testified, this employee stole from me, but the problem was you had there's really nothing else to corroborate the victim's complaint that it was in fact the defendant, and you have the police officer then saying, well, I don't have any reason to, I interviewed the defendant, don't forget that part, I interviewed the defendant, none of the defendant's statement comes in, and I don't have any reason to disbelieve the victim. So the inference, I think that and the improper bolstering there was, well, if you interviewed the defendant and you still believe the victim, then the defendant must not have given a good enough reason why he wasn't the person. And I think that's what came into play. And certainly that's different than what we have here, because Detective Seibert was doing nothing near that. First of all, the 8th District commented and stressed, this detective didn't do anything to corroborate or even investigate what the complaining witnesses had told him. Detective Seibert, on the other hand, testified that he was concerned about, making sure that he confirmed what witnesses were telling him. He didn't just accept it as fact and say, okay, it is what it is. He actually had the witnesses come back to the scene of the murder and show him where they were standing so he could look, one, could they have seen what they're telling me they saw from the position that they were in? Because if you'll remember, most of this takes place, the defendant is in the doorway of a bedroom. There's some people inside and some people outside the bedroom. So Detective Seibert wanted to make sure, hey, can they see what they said they saw? So that was one thing that he did that went way beyond anything in Pruitt. And in doing that, the officers had failed to locate a bullet hole in the floor, and Michelle Neal said, oh no, and Jeremy Brown said this, and James Woods said this, the defendant shot into the floor before he shot the victim. And they didn't find that bullet until they went back, had everyone standing where they were. Michelle Neal is pointing out where the shooter was and where he pointed that gun, and that's when they find the bullet hole in the floor, and they go down and actually, I think, retrieve the bullet. So Detective Seibert's testimony was not bolstering without investigation. He was commenting upon the evidence based on how he discovered things and where the witnesses were and how he confirmed some of what they were telling him. And by having gone back and done that, he certainly discovered evidence that was corroborative of what the witnesses were saying, not just his opinion. This was not a case where Detective Seibert said, in my opinion, or even inferred that it was his opinion that these witnesses were truthful. He was saying, I got all of these statements. There were some inconsistencies, as there are with many, many cases where you have multiple witnesses to an exciting or traumatic event. And he went back and tried to sort it out by looking at the physical evidence, by having the people go back and stand where they were, and conducting a pretty thorough investigation. And then he didn't just come into trial and say, I believe these witnesses. He came in and said, this is what I did. This is the investigation that I conducted. And he's commenting upon the evidence. So he's saying, based on Michelle Neal's statement that they had fired, based on these three witnesses saying he'd fired into the floor, they go back and they look and they find this evidence. So it's not a question of bolstering. I disagree with that.
And counsel, regretfully, I need to inform you, you have reached your 15 minutes.
Thank you, Your Honors.
Thank you. Counsel, you have just under 2 minutes.
Thank you, Your Honor. And may it please the Court, in conclusion, Your Honor, I urge just, if you read the briefs, you will see that
We have read the briefs. I'm teasing you.
I know. If you look at the trial testimony, and counsel knows that for your ineffective assistance of counsel, the two-prong and Strickland, and it can't just be based on testimony. But step back and take all the facts into consideration when you make your decision. There wasn't just a failure to object for Mr. Seibert. It also went out with another police officer, and I think they cited 3 or 4 witnesses with issues. Look at that all as a whole, because when you take that as a whole, I think this is one of those few cases where we can look at the compounding effect of multiple issues with witnesses and come to a conclusion on that. When it comes to the intellectual ability, what I'm arguing on appeal is that once we have that set in stone, we have a stipulated IQ that is that low. At the competency hearing, we are dealing with a panel of experts. The state's bringing their experts in saying, X, Y, Z, this is why he understands. Defense is bringing their own exhibits because it's capital, or their own experts at that time. They're fighting. Well, all of a sudden, when a few months later we have both the parties approaching the court and stipulating to that low of an IQ, that I think that puts alarm bells off for everybody that, you know what, let's revisit that issue. And thank you very much for your time. You're out.
Thank you. Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides, as well as posted on the Ohio Supreme Court website.